It's pretty much every homeowner's nightmare. You've got this mysterious water leak, it's damaging your property, and you're almost certain it's coming from next door. So you turn to your homeowners association for help, but what happens when they tell you their hands are tied? Well, we're going to break down a real-life legal battle that hinges on that exact question, and it really reveals what your HOA is, and maybe more importantly, isn't required to do for you.
So just imagine this for a second. Every single time it rains, water is seeping into your home. You've checked everything, and you are positive the source is your neighbor's property. So you do the logical thing, right? You call your HOA, expecting them to step in and fix this. But what are they truly obligated to do? Let's take a look at one homeowner's fight to find out.
All right, so let's meet our main character in this story, Susan Abbass. For over a year, she was dealing with this incredibly frustrating and recurring problem, a water leak that just kept happening and seemed to have no origin on her own property. And that led her into a long and pretty complicated dispute with her HOA. So from Susan Abbass's point of view, the problem was crystal clear. For more than a year, every time it rained, she got water damage. She even hired inspectors who confirmed her own home wasn't the source. So, naturally, she started to suspect the water had to be coming from her neighbor's property. And she did what most of us would do in that situation. She called her HOA to step in and help out. Okay, this is the point where a simple maintenance issue starts to get messy and turn into a complex legal fight. The HOA did get involved, but their response, well, it was not what Miss Abbass was hoping for, and it led to a really fundamental disagreement about what their duties actually were. And this is the absolute heart of the conflict. On one side, you have Susan Abbass, who sees this as a total emergency. She's arguing the HOA has a duty, a responsibility to force an inspection on the neighboring property, and she even offered to pay for it herself. But on the other side, the HOA is being super cautious. They're saying, look, our rules give us the right to enter a property, but that's not the same as an obligation or a duty. They were really worried that if they forced their way in, they could get slapped with a lawsuit from the other homeowner. So, to be fair, the HOA didn't do nothing. They did contact the neighbor, they even sent a warning letter about some overgrown vegetation that might be causing a problem, but they drew a hard line at forcing an inspection. In their eyes, they had gone as far as they legally could without overstepping their authority and putting the entire association at risk. Of course, for Ms. Abbass, this wasn't nearly enough. Frustrated and feeling like she'd hit a brick wall, Ms. Abbass took the next big step. She filed a formal petition against her HOA. And just like that, this neighborhood dispute was moved into an administrative courtroom. This was going to be the first real test of her argument. And let me tell you, this was not a quick process. The case started with the initial filing way back in May, and it didn't get a final decision until December. We're talking over 7 months with multiple hearings and legal filings. It was a serious commitment of time, energy, and, of course, money. So the judge's initial finding sided with the HOA, and it all came down to that key legal distinction we talked about just a minute ago. The judge said the HOA had the right to enter the neighbor's property, but Ms. Abbass just couldn't prove they had an obligation to do so. It's a really subtle difference in wording, but in the eyes of the law, it's absolutely massive. But believe it or not, the story wasn't over yet. In a pretty surprising turn, the court actually granted Susan Abbass a rehearing, which is a rare second chance to try and prove that that initial decision was flawed. So, you might be wondering, how do you even get a second chance like this? Well, you have to argue that the first decision was, and this is the legal jargon, arbitrary, capricious, or an abuse of discretion. That is a very high bar to clear. You're not just saying the judge got it wrong. You're basically saying the decision was so baseless or illogical that it was an abuse of their judicial power. Now this is where the case really takes a decisive turn. At the rehearing, Ms. Abbass didn't present any new evidence or any new witnesses. The HOA, on the other hand, came prepared. They showed up with photographs suggesting that the water drainage on the neighboring property actually flowed away from Ms. Abbass's home, which directly challenged her central claim. And this just highlights a critical lesson. Documented evidence is always going to be more powerful than suspicion alone. Okay, so before we get to the final verdict, it is super important to understand this concept. The burden of proof was completely on Susan Abbass. She had to prove her case by a preponderance of the evidence. Now, this isn't like a criminal case. It's not proof beyond a reasonable doubt. It just means she had to convince the judge that her story was more likely true than not, even if it was just by a tiny 51 to 49% margin.
So, with no new evidence from the homeowner and new contradictory evidence from the HOA, the judge was ready to make a final binding decision. So, how did it all wrap up? The judge's final logic was actually pretty straightforward. First, he said the burden of proof was on the homeowner, period. Second, she didn't provide any new evidence to meet that burden. Third, all the evidence showed that the HOA had acted within its rights and followed its own rules. And all of that led to the final verdict. The HOA wins and the case is dismissed for good. And it's also important to remember the real-world costs here. Just to get this process started, just to file that initial petition with the state, Ms. Abbass had to pay a $500 fee. And that's before you even think about any other potential legal costs, which just goes to show you that taking on your HOA isn't just an emotional investment, it's a financial one too. Okay, so if you take one thing away from this entire case, let it be this. Your HOA's governing documents, your CC&Rs, they might give them the right to do all sorts of things, like inspect a neighbor's yard. But that right does not automatically create a legal obligation or a duty to act. Before you escalate a dispute, the first thing you have to do is prove your case with solid evidence, because without it, your HOA may choose not to get involved. And this really brings us to our final question, and this one is for you. We, as homeowners, we often focus on the power an HOA has over us. But this case kind of flips the script, doesn't it? It challenges us to look at our own governing documents and ask a totally different question. What is our HOA truly legally obligated to do for us? The answer, well, it might be a lot more limited than you think.